Bill Part heard in the matter of Prudential and the Commissioners HMRC.
Sorry to keep you waiting, Mr. Mantle. I was waiting for my clerk and she was waiting for me. My fault, not yours.
Not at all. Your Lordships will remember that I was about to move on to the Thorn case, so to look at the cases on the disregard provision. But before I do that, can I just pick up on something Lord Justice Underhill said yesterday, that really this wasn't a case in which the AC were asking you to apply some meta rule. It was a case where they were asking you to apply an absolutely straightforward rule about when services were actually rendered.
Yes.
Of course, you've already seen Article 63, which is the one of three time and supply rules. Would you like to see it again? It's bundle tab 4, page 34.
Yes.
Chargeable events occur and VAT shall become chargeable when the goods or services are supplied. But you'll see, and contrary to one of their friends' submission, Article 64 doesn't rank any lower than Article 63. There's a special provision which applies not least to continuous supplies of services at Article 64. So it's where something gives rise, supply gives rise to successive statements of account or successive payments. And you'll see that that applies to the supply of services over the page on page 35. And so that says that you should look to when the supply of services are completed, and that's treated as being at the end of the periods to which statements or payments relate. So what's the point of taking you back to that, I ask rhetorically? Well, it's to show you that even within the PVD and legislation of the PVD itself, they clearly recognise that continuous supplies of services create particular problems, which may not be well catered for by just asking when the services were actually rendered, as happens in Article 63. So I dealt yesterday, I ended up focusing on straddling supplies before and after a member leaves.
Just before we leave
Yes.
that point, I haven't really focused on why this is treated as a continuous supply, because that's not an issue. But the problem we have here could arise outside a continuous supply situation, couldn't you? Could you have a one-off supply of a service, but which generated a later invoice outside a post-demerger, to use my lord's shorthand? In such a situation, how would the time and supply rules work?
Well, the time and supply rules, Article 65, allows VAT to be chargeable no later than the time the invoice is issued, or no later than the time the payment is received. You see that on page 35.
66, you mean?
Yes. So if the time of supply was fixed earlier, for example, by Article 63, or the UK rule implementing it, then that wouldn't apply. So
I'm sorry. No, I'm fine. I'm first thing in the morning. I'm just taking my brain.
No,
maybe a non-point.
I think that is the answer to the question, which is a very reasonable question, if I'm permitted to say so. But you do find the answer in the scope of what the UK is permitted to do, and scope of what it's done. So the UK legislation, which we needn't go to, follows that pattern.
Sorry, I haven't quite answered. I mean, you clearly can have something supplied at time T1 on terms that some payment is made then and some payment is made later. A typical case is when you sell land subject to an overage clause. You pay the completion money on completion, but if the overage clause is triggered, there's a subsequent payment. So you can have a one-off supply of something, not a continuous supply, one-off supply with two payments, one at a time and one at a later time. How does the UK tax that for VAT purposes?
I think that's taxed in. Should we go and look at the time of supply rule? So that's Rule 6 on page 7 of the bundle. And if you look at 6.4, my lord, that was, I think, that was the rule in its earlier incarnation in the 1983 Act, which was being considered in Thorn.
Thorn was when you have an advance payment in advance, in that case 90% in advance of the actual supply, which took place after the group. How does it work where you have a subsequent payment?
Well, Lord, I think the answer is that VAT, the VAT time of supply rules don't postpone the time of supply because payment hasn't yet been made in full.
So the time of supply is, in my example, on completion. Does the subsequent overage payment attract VAT or not? You would have thought it did, but how does that happen?
My lord, I think it does. I'm not sure what the practicalities are in terms of ascertaining if the amount is unascertained at the date of completion and can only be ascertained later, whether an overage or anything else. In my submission, that will be dealt with by provisions which address an increase or decrease in consideration after the time of supply, not by the time of supply rules. So you wouldn't be put in the invidious position where you had to account for something that you did not know the additional consideration you didn't know the value of. But when that consideration was received, you would be required to account for it as consideration for that supply. Time of supply wouldn't be altered.
But perhaps it would be helpful, probably like those points raised at least by this member of the bench. It turns out to be a red herring at the end. But since we've raised it, I think, could you, or those behind you, or those behind Ms. Yang, I can see some orange books being perused, identify the provisions that would apply in really any situation of deferred consideration for a one-off payment, where there's no doubt when the time of supply has been, but there is at that point there's the possibility of a further payment, but the amount isn't yet known. I think that's the situation where.
Can I just add to that? And I'm sure this is a complete red herring, but just so I understand how it works, thinking back to when I was a barrister, which you obviously are, you didn't account for VAT until you got the money, and you didn't issue a VAT invoice till you got the money, as I remember. The invoice said it was only a VAT invoice when receipted or something. But the services are obviously supplied earlier. And on the face of it, the general rule is that VAT becomes due at the time of supply. So how is it that where barristers supply services, they don't have to account for VAT till they get the money?
Barristers are subject to a cash accounting scheme, which certainly
It's a
applies to
special-
if I think it applies specifically to them. I can't now remember whether it's
So sorry, I might just assist. It's regulation 92 of the 1995 VAT regulations.
That's the barrister
It's
case.
the barrister case.
Yes, yes, I see.
The services supplied by a barrister when Scotland by an advocate acting in that capacity shall be treated as taking place at whichever is the earliest of the following times. A, when the fee in respect of those services is received by the barrister or advocate. B, when the barrister or advocate issues a VAT invoice in respect of them. Or C, the day when the barrister or advocate ceases to practice as such.
Yes, I see. Thank you very much.
So the earliest of those three.
The earliest of those 3 days.
Yes, so you did have, yes. So how does that solve the problem? You'll issue your VAT invoice promptly.
I think it's only a VAT invoice when receipted, isn't it?
maybe or one issues a demand for payment,
Yes.
and one then receives payment, and then one
may not
issues a
be
VAT
listening
invoice
carefully.
after
Yes, I
payment's
see.
been received.
Yes, I see.
That's certainly practically how it works in my chambers.
Yes.
But that is a special rule for barristers. So normally, if you're a trader, you supply
Yeah.
services, maybe one-off, and it then becomes due, even though you don't receive payment
Yeah.
until later. Is that not the case?
Yes.
And there's a bad debt, or I can't remember what it's called. I mean, it's very basic stuff, which I'm embarrassed not to know. But there's effectively a provision for recoupment when it's definitively a bad debt. Is that right?
There are bad debt relief provisions in the 1995 regulations, which allow a reduction of the consideration for a supply in the event that certain conditions, including not receiving the consideration, have been met after a certain period of time. And there are also provisions which are referred to in Thorn. We don't have them in the bundle, but which are in the PVD, specifically about altering the taxable alterations in the taxable amount. If I leave those behind me to look, and perhaps particularly look for the provision in the PVD rather than breaking my submissions now.
Yes, absolutely.
to
Well,
identify.
we've got even further away from my original query. But going back to my original query, if someone could find the provisions that govern that situation.
Yes,
that would be
I think it's your. We'll get the provisions, but I think if you look through section 6 and the time of supply rules, you see in section 6 the rule which provides that you the rule which deals with payments on account, which I took you to. You also see the rule which advances the time of supply to when an invoice is rendered or where payment is received, but there is no equivalent provision in section 6 or generally in the regulations which simply postpones time of supply where you've rendered the services in a one-off from that date of rendering the services till when you've rendered the a VAT invoice or received payment. And in a sense, the demonstration of that is what my learned friend helpfully pointed out, that there is a special provision for barristers effectively achieving that, but it has to be achieved by a special provision.
That raises, I'm sorry, it's another query, but arising out of Regulation 92, suppose a barrister at the outset of their career, their turnover does not reach the VAT threshold, so they're not a registered person and they supply services, have a brief to appear in the Crown Court, and like most legal aid payments, they don't get paid for years. By the time that they are paid, they are registered for VAT. Do they have to account for VAT on that fee? Under the time of supply rules, it only becomes due, according to Regulation 92, when they're paid, by which time they are registered. Do they in practice pay VAT on fees earned when they weren't registered? Well, you probably don't know. But it's a similar question to the question in the current case. And one would have thought it happened on a very regular
I
basis.
think it's a similar question to the question in BJ Rice.
Yes.
Yes.
So I think the answer would be that if one was completely analogous with BJ Rice, so one had actually performed all of the relevant services at a time where one was not a taxable person, one had rendered an invoice also at the time one was a taxable person. The fact that you were paid after you were registered for VAT would not mean that there was a chargeable event at that time. But the commissioners take that view on the basis that although the reasoning in BJ Rice was heavily criticised by Lord Hoffman in Thorn, and then criticised by Lady Justice Arden, admittedly dissenting, in RSA, where she said that
The result might be right, but the reasoning might be a bit too broadly expressed.
that's what Lord Walker said. She, I think, more said it ought to be confined to its own facts, which probably comes to the same thing, I think. And she pointed not only to the services having been entirely performed before BJ Rice became a taxable person, but also to the invoice having been delivered. Then one has Lord Walker emphasising the invoice again and saying effectively, I think, saying that the reasoning should be confined to its own facts, but the case that means to say the case is wrongly decided. Now that's important because it's a bit of a strange way for it to come about, and I will take you there. But when we look at the decision of Lord Justice Hoffman for the majority, which included Lord Walker in RSA, there were two dissenting judgments from Lord Wolfe and Lord Clyde. Lord Hoffman adopts the reasoning of Lady Justice Arden, which must include paragraph 47 in relation to BJ Rice. So he is reiterating and accepting what he'd said when giving a dissenting judgment in Thorn. That then, Lord Steyn just agrees with him. So that it could have been a majority judgment saying, well, BJ Rice is wrongly decided, it's overridden.
But it doesn't do it. It doesn't do
Isn't, because Lord Walker takes the trouble to say, I paraphrase, I don't agree with the reasoning, but that doesn't mean in the special facts of BJ Rice that it was wrongly decided. And the difference between BJ Rice, we would say, and your barrister before registration, VAT registration example, is they're entirely outside the scope of the VAT system.
I see. So that my question prompted quite a long answer, which anticipates stuff you're going to say later. But as I understand it, the Commissioner's position is that BJ Rice continues to apply on its facts and on analogous facts, such as the unregistered barrister, but the reasoning is too broadly expressed and doesn't apply to our facts. Is that the position?
That's a very succinct expression of my client's position, yes.
Yes, thank you.
So it's a while since I promised to get on to Thorn, but I did want to make this point about continuous supplies. Now we've looked back at the regulations, and you've asked for more on regulations and what happens with the change in consideration. We'll try and provide you with that. But I'd say this, there's an acknowledgement between, given the arrangement of the time of supply rules in the PVD, that it won't be always easy, straightforward or right to just ask the question, when were services actually rendered? And there's a special provision which deals inter alia with successive, continuous supplies of services. And the point I wanted to make, it's taken a long time to get there, so my apologies, is that there may be in some cases when you're looking at continuous supplies, more than one reasonable answer as to when the services were actually provided. There may be cases like this where there's only one reasonable answer to when the services were actually provided, but not always so. There might be reasonable disagreement as to whether a particular continuous supply of services was made only when both companies were in the VAT group, or only after one company had left the VAT group, or across both. So it might straddle.
Give us some one or two examples of cases in which there is no objectively right answer, or there's room for more than one reasonable view as to when services have been provided.
So can we take before and after a particular date, which would be, say, when somebody left a VAT group, or it could be when somebody joined a VAT group. So let's say there's a project and it involves continuous supplies of services, and the majority of work is done by the date. But there are snagging works that have to be carried out after the date. And it needs some legal context. As we know, the starting point for most VAT analysis is the contract. So let's say this is in an entire contract and the supplier is not entitled to anything until all the snagging is completed. So you might take a just realistic, real-world view that so much of the work was done before the date that ought to be the date of supply. Or you may take a more contract-focused view that the work had to be completed before any payment became due, and therefore it was necessary to look at the date when the work was actually completed. Or you might take a realistic view and say, well, I can't dismiss the snagging work as de minimis, so I'm going to say that this was a straggling type supply, partly provided before the date and partly provided after the date. So that was the example that I had I proposed to give. So can I now go to Thorn? And I go to Thorn and these cases to deal with ground one, which relates to the disregard. To a large extent, firstly, to deal with the ground 1.1, to see what's actually been said again. You have all the context now, so hopefully we can go more quickly. What was said by their lordships about applying or not applying the time of supply rules in these cases, knowing that the scenario isn't exactly the same, but nevertheless we say highly persuasive because of that. And also because ground 1.2 relies on BJ Rice, to see what's been said about BJ Rice in the context of VAT grouping by Lord Hoffman, and then how that's taken up in RSA. So if we could go to page 81, please, which you've seen before, and if you could just read what Lord Nolan says, speaking for the majority, of course, around letter B.
Down to
I think down to the end of that paragraph.
just down to C, or down to
Just
E?
down to C. And all I need to flag is that his lordship says time of supply rules must be applied to determine whether and if so when a supply took place between members of the same VAT group. It's essential to apply the time of supply rules in order to determine whether the supply took place while the group relationship still existed.
I mean, on the face of it, that's extremely helpful to you, obviously.
Yes.
that you accept as obiter, do you?
No. In that case, it was necessary to form a view as to whether to apply the time and supply rules or not. You couldn't have reached the conclusion without doing so. Clearly, all of the judges had given thought to the matter. It's right to say that Mr. Prosser submitted that they should be applied, and one doesn't see any specific objection to that, but it certainly doesn't seem to be treated as a given. Why it's not binding in our submission is because it's not precisely the same scenario as here. Here, we're looking at services which were actually rendered in the VAT Group. In Thorn, actual delivery of the goods was after the member had left the VAT Group.
Just say it again. I know it's just done accurately.
So here, actual rendering of the services is when both companies are in the VAT Group. In Thorn, actual delivery of the goods was after one company had left the VAT Group. And it's for that reason that we submit this is highly persuasive, not binding.
I mean, I don't suppose you are, but could it be arguable that you're underselling yourself there? That of course the facts are different, but the principle applied is of its nature, must of its nature be one of general application. I'm sorry to make you argue against yourself, but I'm just...
No, well, I do say it's unqualified.
Yes.
And on the face of it, it would be a principle of general application. But
you're being fair and saying...
yes, I hope so.
Yeah,
It means
well, sure.
that you ought to consider that difference and whether that makes a difference. I suppose the position is if that doesn't make a difference, then you could conclude that you're bound by it. So I mean, obviously that's a matter for you ultimately, but I rely on it being highly persuasive. And when I come to Svenska, of course, Svenska deals with the very same time as supply rule, regulation 90, and it also deals with should you pay attention to what actually happened, or do the time of supply rules?
Well, we'll get to Svenska in a minute, but I mean, it's a classic problem which we ought to have at our fingertips, but I have to remind myself each time of exactly whether in situations like this, the extent to which the fact that there's a different factual scenario prevents something being ratio. Maybe practice of courts isn't quite consistent on that.
Well,
sometimes we say it is. Sometimes
I would say this is ratio in Thorn, but it doesn't bind you.
Yes, I see. Sorry, you're quite right. Whether it's a relevant ratio.
Yes.
Okay. Well, I see exactly why you put it that way, and you're probably right. I didn't suppose remember yourself, but I just wanted to formulate it myself.
And just anticipating where obviously you're going to go, supposing one took that in an unqualified way and looked to the thinking behind it, given that the commissioners are not seeking to argue that BJ Rice is wrong on the facts, one has to work out what the reconciliation is.
Yes, and the reconciliation, we'd say the difference from BJ Rice, the key difference from BJ Rice, is BJ Rice is entirely outside the scope of the VAT system when supplies are actually rendered and when it's invoiced, whereas that's not the position of Silverfleet. Silverfleet is part of a VAT group, an ordinary member of a VAT group. One of those persons that's being treated as a single taxable person is not outside the scope of the VAT system in the same way as Mr. Rice was.
And obviously you'll develop that, but you get clearly from Thorn that you can have a supply regardless of whether it's taxable or anything. So once you've found a supply, you say to yourself, look at the time of supply rules. The time of supply rules tell you that the time of supply is the time of payment. At the time of payment, BJ Rice was registered. So why, if one simply applies the time of supply rules to work out when the supply was relevantly provided, don't you conclude that BJ Rice is wrong?
Well, certainly in our submission, and as Lord Hoffman says, you come to the conclusion that BJ Rice is wrongly reasoned. The reasons other than the application of the time of supply rule seem to be based on unfairness in large part, but they also seem to flow from unfairness because at the time of the actual rendering of the services, the supplier was entirely outside the scope of the VAT system and had done everything he could to finalise the transaction. Obviously, he couldn't pay himself, but that's the difference, where you're dealing with somebody who's entirely outside the scope of the VAT system.
Can I ask you a different question, which is, to what extent was what Lord Nolan said in the passage you asked us to read in dispute between the taxpayer and the commissioners in Thorn? Lord Nolan's statement of the opposing arguments is at page 78, towards the bottom of the page. If I read that, it was effectively common ground that you applied the time of supply rules and that you had to disregard the 90% which took place within the intra-group period under those rules. The issue was, what was the effect of disregarding it? And the taxpayers said, as Lord Hoffman accepted, that means that 90% of the price wasn't vatable and only 10% was vatable. The majority said, by disregard, you treated it as if it didn't happen, and that meant that 100% was vatable. But there doesn't seem to have been any dispute that there was a disregard of some sort, and that could only come from applying the time of supply rule. So, to what extent was what Lord Nolan said at the top of page 81 actually in issue?
Well, I think it may be one of those unusual cases where, of course, the House of Lords has to deal with the judgment of the court below.
Yes.
So the parties before the House of Lords, certainly we know what the taxpayer's submission was. I agree, to put it very briefly, that does seem to be the nub of the position with the commissioners. The commissioners don't seem to have been disputing that. But of course, a different view had been taken by the Court of Appeal below, as we've seen from looking at Lord Hoffman's judgment. So it wasn't something that just comes lightly into the committee room in the House of Lords. They do have to satisfy themselves, whatever the parties say, that the Court of Appeal had got it wrong. So in our submission,
well, that raises, sorry to interrupt you,
Yeah.
This question. If the Court of Appeal says X and the appellant appeals saying that's wrong, the answer is Y, and the respondent doesn't really argue to the contrary, is what the House of Lords says when it says that the answer is Y and not X, is that binding on subsequent cases, or is it something that has proceeded by way of concession and is therefore not binding? I don't know what the answer to that is.
I mean, there are 2 or 3 cases, aren't there? I can't. Is one called Tredim? There's a limited number of cases which explore exactly this question, the extent to which a point which is clearly central to the reasoning of House of Lords or the Supreme Court but was not disputed, the extent to which you can say, well, it's not binding because that was merely an assumption. I think the law is quite subtle about this, is my recollection. I think we perhaps will need to look at those cases. And I may have missed, I think one's called Kadim, Kadhim, but I may be misremembering. I think the law is quite subtle. It doesn't simply say, well, if it was conceded, it can't be binding. It's the extent more, not so much about the conceded, more to the extent to which the court of the Supreme Court must have thought about the point or considered the point. I just didn't take for granted. In your point that they were departing from the way in which the Court of Appeal had reasoned it, would play into that analysis. But I think it might be sensible if those behind you could identify those cases. I'm afraid I can't at the moment. Kadim is not the most recent.
Well, I've come into this court intending to, and with instructions to argue that this reasoning is highly persuasive.
Yes.
Including for the reasons that your lordship has just mentioned. I can see that it would be helpful to your lordships to get more clarity on that. I suppose I retreat to my backstop and say, if after that clarification it's not binding because of the circumstances of departing from the reasoning of the Court of Appeal, because of what Lord Hoffman says on the time of supply rules and how that's then picked up in RSA, it is all highly persuasive and should really have no lesser impact on you, other than you need to be satisfied that the subtleties don't lead you to treat something as not binding when it is.
I see that, and that may be enough for you, because if it is a sufficient basis for us to construe the ratio of BJ Rice narrowly, which is really what you're asking us to do, fine. But it's not impossible. We could find ourselves in the situation where we didn't find it possible to construe the ratio of BJ Rice narrowly, in which case we'd have to find somewhere that it had been overruled. And at the moment on your current instructions, you're not asking us to do that. I'm not asking you to change your stance, but you can imagine we just want to make sure we have all the right tools to analyze this accurately. If we were going to decide it on a basis that hadn't been argued, we certainly want to give Ms. Yang the opportunity to address it. At the moment, we're patching ahead of ourselves. It was raised by my Lord's question, but understandably, because we've got to think around the problem. So if those behind you can just see if they can identify, may not be possible without going to without doing more work than you can do while listening to your submissions. We may have to have a note about it afterwards.
Yes, that occurred to me as one never wants to prolong things and draw it out and have exchanges, but that may be the way to best serve you.
Well,
we can see.
I think for the moment, in fairness to Ms. Yang and indeed to you, we must proceed on the basis that you're instructed to argue it. But we would be grateful for a note on what the correct position is about something which was otherwise binding, would otherwise appear to be ratio, but was not argued or proceeded on an assumption. I'm pretty sure that's the way the language appears in the case law.
So, I can see as we dissect the reasoning how important that is. So, yes.
Yeah. Well, let's put that to one side for the moment and
So,
argue it as you were proposing to argue it.
well, I asked you only to read on page 81 down to the paragraph beginning at C. Can I just draw two, I think, quite important passages in that next paragraph to your attention? I'm not sure whether you've read that already or not, Perhaps it's just easiest to invite you to read the whole paragraph, and then I'll tell you what I want to flag. If
So
you
C,
would
C
not
to
mind.
E.
Yes.
Yes.
So I appreciate, one might say, this paragraph is dealing with effect rather than application of the disregard. But only a paragraph before Lord Nolan says this, he's referred to must and the essential to apply the time supply rules. And even though there's been helpful jurisprudence of the Court of Justice since Thorne, you can see essentially he has the purpose, the key purpose and consequences of what's now Article 11 correct. Article 11 and VAT grouping. They're designed to simplify and facilitate the collection of tax by treating a representative member who are carrying on all business of the other members as well as its own and dealing on behalf of them with non-members. And lower down at E, enable a group to be treated as if it were a single taxable entity, even though it's not expressed in those terms. So he has correctly in mind the purposes of Article 11 in this judgment. Could we then go to Lord Hoffman and page 82? Can we just go to briefly, because I think we looked at this passage. I think my Lord Lord Justice Newey drew attention to this yesterday between E to H, which I think is referred to later in the reasoning of Lord Hoffman. And then it's on 86F to 87E, which we've already seen. Can I just ask you to look at that again?
The second reference is 86F.
To 87E.
Yes, I see.
And within that, the sentence, the time of supply rules are, in my view, the only criteria for deciding whether the taxable transaction is treated as having occurred at a time when it was taxable.
Yeah.
So here and below, my learned friend has made the point that Lord Hoffman was dissenting. But with respect, he wasn't dissenting on this point. He was just giving extended reasoning for why the Court of Appeal were wrong, and it was right to apply the time of supply rules. And he's also dealing with why BJ Rice shouldn't be taken to give any assistance to an argument that when looking at VAT grouping, you should not apply the time of supply rule in order to determine for the purposes of the disregard, paragraph A, whether the supply occurred when both supplier and recipient of supply were members of the VAT group.
Now, can I just take that a stage further? If you look up the page on 86, just below D, you get Lord Hoffman talking about the case of a company which agrees to supply goods, receives the whole price in advance, but before the goods are delivered, joins the same group, and so on. And then he says that Mr. Fleming seems to accept that you'd be entitled to get the money back. but Lord Hoffman says that seems an extraordinary anomaly. Now, is that flatly contradictory to the passage that Miss Young was taking us to back in 80, at letter D?
In my submission, not, because in my submission, what this is doing, as the Upper Tribunal rightly held, is working out the consequences of applying the time and supply rule. And here, one has, on the counterfactual, one has a time of supply rule which places the delivery within the VAT Group. So what's the consequence of that? Well, the consequence of the disregard, says Lord Nolan, would be in those circumstances that you had to disregard the supply in its entirety. And the fact that the time of supply rule provides it for an extent to be supplied at an earlier time, that would not matter. So that's, I think, the difference in what the consequences of applying the disregard where you have this particular time of supply rule are, and that's what your lordship juxtaposing these two passages, it shows that that's what Lord Hoffman and the majority were disagreeing on, which was what are the consequences of the disregard, and they're disagreeing on the consequences of a disregard that doesn't apply here because we have different time of supply rules. So the question there is, well, when you have one supply, here we have separate and successive supplies under Regulation 90.
And just staying with the passages you were drawing our attention to, really, Lord Hoffman's reasoning is to the effect that BJ Rice is just wrong.
I beg your lordship's pardon, is just repeated by?
Really, is it not right that Lord Hoffman's reasoning is to the effect that BJ Rice is just wrong? And were that right, then Lord Hoffman's approach wouldn't seem to provide a reconciliation in this case, in circumstances where HMRC are not suggesting that BJ Rice is wrong.
Well, we're saying that the reasoning is wrong. We're saying that you can't say that it's wrongly decided in terms of outcome. If Lord Walker had not inserted the sentence that you've been shown, saying that it didn't follow that BJ Rice was wrong, then we would have had a majority in the House of Lords, Lord Steen, Lord Hoffman and Lord Walker, which would, in our submission, perhaps I'm getting ahead of myself, so, which would have overturned. So what we say is effectively happened is the reasoning has been disapproved. The case hasn't been overruled because of what Lord Walker said. There was no majority to overrule it, but it has been confined to its facts.
Well, all right, but you are getting ahead to RSA.
Yes.
So far as the reasoning here is concerned, do you accept that Lord Hoffman, on the face of it, is simply saying that it's wrongly decided, not saying that it's right or maybe right, but for the wrong reasons? He's saying it's wrong.
Yes, that seems to inexorably follow from what he says. Now, it was not a battleground you wanted to be above the dust of whether Lord Hoffman had taken into account the standard canons of construction concerning common sense and just and fair interpretation. But in our submission, what your lordship suggests to me is right.
If that's so, if you're relying on what he said here, what my lord was putting to you is that can't really offer a reconciliation with BJ Rice. And that's, I suppose, why you moved on very quickly to RSA, because you say that does.
That's exactly the point,
Precisely.
because should we?
Yeah.
Yes.
Just before we do, because I don't think it adds terribly much, but Lord Justice Nugee did mention Lord Clyde's reasoning on page 89, and it's there for you to consider it and make what you want. But in our submission, that's also consistent with the argument the commissioners are making about applying the time and supply rules, and not really consistent with my learned friend's submissions.
Before you leave Lord Nolan, Ms. Young placed emphasis on the passage that Lord Justice Newey referred to a moment ago, D, which is the counterfactual example where you have an advance payment before you join the group, and then the supply, the actual physical supply, once you've joined the group. And Lord Nolan accepts, I think, here, unlike Lord Hoffman, that means you treat it as if there was never a supply, and you get your money, your VAT back, which you had accounted to the commissioners for on the advance payment. Ms. Yang says that that's a significant passage which reinforces her submissions. Do you want to say anything about that?
I think more about that. Well, it's a single supply. The time of supply hasn't created two separate supplies, and it has to be. It's the operation of the disregard. So where you have the delivery within the disregard, the majority consider that the operation of the disregard is to mean that you don't have a supply at all. That single supply doesn't exist, and therefore there cannot be an earlier time of supply. But that's the operation of the disregard, not whether one is subject to the disregard or not. And that's the distinction that I would make. And then it might be said, well, one needs to consider that I do say the significance in the fact of the particular time of supply rule that was being looked at there. And when we come to RSA, I'll show you the distinction that Lord Hoffman made between that time of supply rule and regulations
So
85.
the time of
90.
supply rule in Thorn apportioned the price to different times,
Yes,
but it was still only one supply.
still only one supply.
Whereas Regulation 90 has successive and separate supplies.
It does.
So that if it was a Regulation 90 case where 90% was pre-group and 10% in the group, you could still keep the tax on the 90% because it was treated as a separate.
You'd have 9 separate supplies, presumably
Outside the group.
outside the group, and 1 inside, which would be disregarded.
Yes, I see.
So I think that does further illustrate that it's how the disregard operates, not how you decide whether you apply the disregard to a particular supply.
So it's what Lord Nolan says in that passage is consistent with applying the time of supply rules first to identify how the time of supply rules work. Then you see which part of a supply takes place within the group period and has to be disregarded, and then you see what the consequence of that is.
Yes, so it's certainly, if one looks at that example, Lord Nolan is applying the time of supply rules. And then you get in this single supply, it's partly within the VAT group, and you have to look at the effect of the disregard. And to some extent, that's the main issue in the case as well. So it works with, on Nolan's advice, when you get that time of supply rule, it's either all inside the group or all outside the group. On the factual, it's all, you apply the time of supply rule, it's all outside. The disregard means that all of the consideration is treated as applicable to the supply after the member has left the group. On the counterfactual, all of the consideration is treated as applicable to the supply inside the group, so it's all disregarded. So you don't get a 90.
So there is a crucial distinction between that time of supply rule, where it's all in or all out, according to Lord Nolan, our time of supply rule, where you say the time of supply rule divides it into separate supplies, and that the management fee part of the supply was in the group, but the performance fee part of the supply is treated as being outside the group, and so not disregarded.
Is that is a very particular type of supply rule,
Yes.
because it creates it treats a single supply to an extent. Unless there's anything I can
No, I
add
think,
on that.
I'm sorry to take you over it again, but I think I do understand the way. I think I understand the way in which you put it.
So we say perhaps we could just look at Svenska as well. In some senses, it's logical to look at RSA next because the RSA deals with BJ Rice, but perhaps we could look at Svenska. That's in tab 8. And could I invite you to go to a passage which I don't think you've seen on page 104? It is sidelined there. It may just help a little because it sets out most clearly what argument the House of Lords are dealing with. It's where it's sidelined between D and E. And so the thrust of the argument was the time of supply rules didn't alter the fact that supply of services had taken place actually at an earlier time, and that was, he said, critical. And then if you go over the page 105, at C2D, that single paragraph. And I don't think we need to look at any other passages, but that's applied. Therefore, there's no supply until both companies are members of the VAT Group, and therefore there is a disregard of those supplies, despite the fact that they were actually carried out earlier. And the fact that they were actually carried out earlier is of no relevance. So there was no dispute about the application of the time of supply rules here, perhaps unsurprising in the light of what was said in Thorne. What this adds is another House of Lords constitution following the same approach, and also it deals with Regulation 90 and VAT grouping. And it's a clear statement that what actually happens doesn't override the need to apply the time of supply rule. So you can't point the time at which a service was actually rendered and say, therefore, we don't apply the time of supply rules to decide whether or not the section 43(1)A disregard applies. Why it's not the same as this case is that the services were actually rendered before one of the companies joined the VAT Group. as opposed to here, of course, where the services are actually rendered when they're in the factory. Might we move on to look at RSA, Royal Sun Alliance? There's no need to take you back to Mr. Justice Park's judgment. Can we just look at the one paragraph 48, sorry, I think I said 47 earlier, of, it's on page 141 in tab 10. And perhaps as well to, sorry to invite you to read so much again, but could you just read from little d down to the end of the paragraph?
Yes.
So what her ladyship then was identifying was not a taxable person at the time of supplies, raised and invoiced the services in question. I think one can read implicitly before they became a taxable person. And then she incorporates into her reasoning of the limitations of the time of her reasoning on the application of the time of supply rules, Lord Hoffman's dissenting judgment, which we've just seen in Thorne.
No, of course, it doesn't perfectly fit because, as we've been discussing, the Lord Hoffman reasoning would rather suggest that B.J. Rice was just wrong. But anyway.
Yes, and I'm not going through the context again.
Yes. No.
In my submission, what Lady Justice Arden was really saying there is the reasoning in B.J. Rice is wrong, and it should be confined to its facts, which does, I don't think, cuts you adrift on a raft. I think it's a very clear indication that it should be really limited to its facts, and those two features being outside the scope of VAT because you're not a taxable person when you render the services, indeed when you issue the invoice as well.
Why does issuing the invoice make a difference? When you look at what the court said in B.J. Rice, it's clearest, I think, in Lord Justice Staunton's judgment. There are 4 conditions which need to be satisfied to make the supply a chargeable one, and one of them is that you're a taxable person. And since he wasn't a taxable person at the time, he doesn't become liable for VAT on subsequent payment when he is a taxable person. That reasoning doesn't rely upon the raising of the invoice. Why, in your submission, does that become a critical feature of the B.J. Rice decision?
Lord Justice Ward's reasoning as well.
Well, there is, which is much more about how unfair it is, but I don't remember him disagreeing with anything Lord Justice Staunton said.
No, I think that's right. I wasn't going to go back to B.J. Rice. Well,
But I mean,
its potential significance is this.
Yes.
That you, as the person outside the scope of the VAT system, have done everything within your power to bring the transaction to a conclusion, including demanding payment. And demanding payment is relevant at least to this extent. There can only be a chargeable supply if it's a supply for consideration. So you've done everything on your part to bring the transaction, the supply, to a conclusion. And all that's happened is that, in his case, contrary to normal commercial expectations, he's not been paid. I accept there might be situations where there might be some delay in paying and something critical might happen then. but it's not me who's, in a sense, harping on about the invoice, because it's the point that, as we'll see, Lord Walker makes as well. And we're getting very much into well, what's the when do words in judgments bind, when do they not? Could we just look at RSA, it's tab 11, what Lord Hoffman for majority says? Perhaps just do it the old-fashioned way. Could we please look at page 148? Would you look at Lord Steep, I'm going to get it wrong, Staines' speech, please?
Yeah, so that doesn't
Nice
take
short
long.
speech.
Yeah. We can all understand exactly what he means by that. But the significant thing is he agrees with both. Then if we go to page 156. Paragraph 36. I think all you need to look at again, you've seen it all before, is the final sentence, where I find the notion of the same goods or services being supplied over and over again too hard to grasp. In my opinion, the plain effect of regulations treat each successive supply as different from the one before. On this point, I agree with the Tribunal and Arden LJ. And in my submission, part of Arden LJ's reasoning going to that point is paragraph 48, which we see. And then if the distinction between two types of regulations you see at paragraph 39.
Sorry, just before you leave 36, probably because I haven't read the Court of Appeal judgment in RSA carefully enough. Why was the Lady Justice Arden point feeding into her views as to treating each successive supply as different from the one before?
Because essentially, if I'm remembering correctly, the Court of Appeal's approach had been like Park J's, that one should not, the other members of the Court of Appeal approach had been like Park J's, that you should not treat Regulation 90, or actually Regulation 85 in that case, as creating a series of successive and separate supplies. You had to take a more realistic view, and that led to a famous quotation about the VAT theme park being made. I can't remember by which of their Lord Justices.
Or just as Sedley, it sounds like.
I think I won't actually. I ought to remember, but I won't actually. Having said that, might I go to paragraph 39, and you'll just see in that paragraph Lord Hoffman's comments on the difference between the regulations, the point we were just discussing.
Yeah.
So, in my submission, once we've got paragraph 36 in Lord Hoffman's judgment, we've got two judges endorsing Lady Justice Arden's reasoning, including paragraph 48, and therefore accepting all of the attack of Lord Justice Hoffman on B.J. Rice. But, therefore, what's said in page 168, paragraph 83 by Lord Walker is significant.
Which page?
sorry, 168. Paragraph 83 at the bottom, over onto 169.
So really, what you say is even if Lady Justice Arden slightly reinterpreted the extent of what Lord Hoffman was saying in Thorn, that reinterpreted version of what he was saying in Thorn was adopted by her, and her adoption of it is then adopted by the majority here.
Yes. And it's consistent with Walker putting in the rider that he did, that unless he'd put that rider in, BJ Rice would have been considered wrong in result. He clearly says it doesn't necessarily follow that it was wrong in result.
Can I ask you two things? First of all, Lord Walker says that he can't add anything usefully to what Lord Hoffman has said in relation to this. Well, what did Lord Walker have in mind there? Because Lord Hoffman hadn't said anything about BJ Rice.
Well, I mean, my submission is that he had, because he'd accepted. It's all very short in Lady Justice Arden's reasoning, but Lady Justice Arden has, if I put it crudely, incorporated into her judgment the reasoning of Lord Hoffman on this point on time and supply rules in Thorn. And then Lord Hoffman, by endorsing, by taking up the reasoning of Lady Justice Arden, endorses himself. So we go from a minority to a majority.
Well, to make the point I made earlier, endorses her version of himself.
Yes, yes, indeed, my lord, yes.
And then at some stage, though this probably is at the moment, I would like to understand what construction can be given to the Act and the rules and the regulations which would achieve what Lord Walker has in mind, but nevertheless allow you to win this case. I mean, you say, well, we see Lady Justice Arden stating a conclusion, fine, but we have to reconcile that conclusion with the wording of the Act and the regulations. So I'd like to understand how you get to that conclusion while also winning this case.
Well, my submission is in the BJ Rice case, at the time of the actual rendering of the services, BJ Rice is entirely outside the scope of the VAT system.
So where does that fit into the well, don't do it now, but where does that fit into the construction of the Act and the rules?
Well, I'll take your invitation. Not
Don't do it now. No.
When are you going to? I don't mean that rudely. Are you do it when you come back to BJ Rice? I thought at one point you said you didn't need to.
well.
I mean, isn't now as good a time to do it as any, or is it not?
Well,
Sorry, I don't mean that rudely, but I just want to sort of understand where we're going next, so I can. Yeah.
In our submission, the worst position, which we are at the end of reading the RSA judgments, is that BJ Rice is to be narrowly confined. Situation to which it applies is spelt out both by Lady Justice Arden and I think by Lord Walker as well. And then what's said, I think clearly, is you don't extend the approach that's been taken in BJ Rice beyond the situation which it covers. So the obvious distinction then is, well, BJ Rice was entirely outside the scope of the VAT system. He was not a person who was within the scope of the VAT system and sought to rely on a deeming, on a provision such as section 43(1) at all, particularly 43(1)(a), the disregard. So you shouldn't extend the reasoning in B.J. Rice to a situation of interaction of interaction with a provision in the VAT system such as that. Once one's within the VAT system, one should be applying the time of supply rules.
Can I just talk around that for a moment? I mean, in one sense, the thrust of your submission has been, okay, the result might be right in B.J. Rice, but the reasoning is wrong. Forget about the reasoning. Is that a sort of fair summary?
I think that's one way of putting it. I would prefer to put it this way. Note the reasoning so you're aware of what it does, but don't extend that reasoning to other situations, because that's the message which, in our opinion, the Upper Tribunal correctly discerned, and that's the message you get in our submission from RSA.
But if the ratio is X, it's not a matter of extending the ratio, it's a matter of applying the ratio. So if you want to justify the decision without us applying the ratio in all sorts of other circumstances on which it bites, you have to say the result may be right, but the reasoning is wrong, and then you've got to give us a different reasoning consistent with the provisions. So if on one view, the ratio of B.J. Rice is the existence of a chargeable transaction has to be determined at a time when the supply is actually made. Now, you can't live with that, can you?
My lord, if that's just taken as a single general proposition, I think the answer is right. Our approach is contrary to the reasoning of the Court of Appeal in B.J. Rice. I realise it's not at all juridically satisfactory, but the fact remains that if you were to read RSA as saying this case should be narrowly confined, and it shouldn't, its reasoning shouldn't be extended, one may have concerns that hasn't satisfactorily resolved things because one hasn't been told why the reasoning is wrong. But perhaps what's being told is the reasoning is wrong, but it doesn't mean that the result in the B.J. Rice case was right, but nobody's told it was wrong. But nobody's telling us why it is right.
So just coming back, if the result is right, we'll assume it's right. We need to understand how it can be right, consistently with your submissions. Now, we know that you can have a supply even though it isn't taxable, and that's explained in Thorne. So once you've got a supply, on the face of it, you apply Regulation 90. And when you look at Regulation 90, you find that if it's a continuous supply, then it's to be treated as supplied when there's payment. At the time of payment, in a B.J. Rice situation, the supplier is registered, so tax is payable. So how consistently with your submissions do you say that is not right?
Well, my submission is that the reasoning in B.J. Rice is wrong. that
Then do we not need an alternative reasoning that will justify the result?
you need reasoning which justifies the result in this case, but there's no need to, in our submission, try and find alternative reasoning to rehabilitate the reasoning in BJ Rice. And that, I'm not trying at all to be flippant, because I'm also making a very valid distinction here, in the sense that BJ Rice is looking at the situation in which supplies are rendered by somebody who's not, at the time they're rendered, a taxable person. So you can say, on a narrow view of the judgment in BJ Rice, that if somebody is not a taxable person, they're entirely out of the scope of VAT, then Regulation 90 can't operate. Let's assume the invoice has been sent as well before registration, to bring somebody into the VAT system simply on the basis of payment. So that's different from the situation in this case, because I know there's a disagreement between my learned friend and myself. It's clear as a matter of reality and common sense that at the time the supplies were actually rendered, Silverfleet was within the VAT system. It was part of a single taxable person. It was part of the PAC VAT Group. So in my submission, if we're right about that, if that's a valid distinction, it does provide for you the clear demarcation line between where you can apply the reasoning in BJ Rice and where you can't. So, for example, you'd be extremely cautious before saying, well, what BJ Rice is still valid or authority for is that when you have to look at all four of the criteria that were identified for chargeability at the date the supplies were actually made. What you can do is look at the date the supplies were actually made and see if that person was within the scope of the VAT system. And that would be allowing the reasoning to stand, but properly confining it. So only be in that limited scenario that the time supply rules weren't allowed to have their normal effect.
That way of putting it treats as critical the distinction between the supplier, Mr. Rice, being outside the VAT system, and the transaction that being outside the VAT system, because Ms. Young's whole point is the actual transaction was, by virtue of Section 43, to be ignored or disregarded, and therefore wasn't a vatable transaction. It simply didn't count for VAT purposes.
If we're focused on the disregard, as I submitted yesterday evening in our submission, the Upper Tribunal must be right. There's a temporal requirement for the disregard, and you have to apply.
So you'd have to do the time of supply rules before you get to the disregard. I understand the way you put it, but what I was putting to you is that your characterisation, which confines BJ Rice to someone in Mr. Rice's position, focuses on whether Mr. Rice was a taxable person
It does.
at the actual time of supply, whereas Ms. Yang focuses on whether the supply was a taxable supply at the actual time of supply, which it wasn't.
So first of all, I think it follows, if that's right, and my distinction of BJ Rice is right, therefore we have this contrast. BJ Rice is not a taxable person at actual rendering, but Silverfleet was a taxable person at actual rendering. That's the critical distinction from the point of view of BJ Rice. I'm saying
It's only a taxable person in a very attenuated way. Its supplies to PAC weren't taxable because it was in a group. Its supplies to people outside the group were taxable, but they were taxable as if they'd been supplied by PAC. So it's a very attenuated form of saying that Silverfleet was within the VAT system. I understand the way in which you put it, which was it was a member of a group, which was a VAT group, and its transactions did attract VAT if they were outside the group. But that's why I say that your distinction draws a sharp distinction between Mr. Rice, who was not a taxable person, and Silverfleet, although was within the scope of VAT, to use your phrase, didn't make any taxable supplies in its own right while it was within the group, because they were either intra-group, which weren't taxable, or extra-group, in which case they were deemed to be the Prudential's transactions.
Well,
That is the distinction that you have to draw, isn't it?
I think we're back to a chicken and egg situation, because so far as the law of this country is concerned, VATA is concerned, one has to look, interpret and apply section 43. And I'll come on to the assumption, but if one looks at the disregard, it's clear that you've got to establish whether the transaction, you say, but it's supplies. We can say supplies because we needn't focus on community acquisitions or imports. The question is whether the supply took place at a time when the two people were members of the same VAT group. And you need a rule to establish that. And we say clearly, looking at the statute and the reasoning we've seen in Thorne, for example, the answer is apply the time of supply rules. And that will tell you whether the particular transaction it falls within the disregard or not. If the transaction doesn't fall within the disregard, in our submission, it's not to be disregarded. And it's very clear that the focus in terms of intragroup transactions is between, in the domestic legislation, is paragraph A in section 43(1). So, and then, in our submission, and I'll come on to this, the way to look at it is well, is there anything in Article 11 of the PVD which prevents a member state from applying its time of supply rules to determine whether a transaction is an internal transaction of a VAT group, or whether a transaction is a supply of the single taxable person, or whether it's not because of the date at which it's made. And we also say that's a very logical approach to take within the PVD itself, because the PVD only provides the time of supply rules that we've seen, and there are no special time of supply rules applying to Article 11. So it would seem to be the logical way to determine whether a particular supply is or is not an intra-group transaction or a transaction made to or by the representative member.
Yes, thank you.
And I don't know.
But can I just be clear about RSA? Assuming is it your submission that the fact that, in the way that you've described, 3 members of the Supreme Court, House of Lords, say that BJ Rice must be treated as applicable only in the situation identified by Lady Justice Arden is binding authority that, even if we might have some difficulty in seeing exactly whether that's reconcilable with what they actually said, that is now the authoritative statement of the extent of how far BJ Rice goes as a matter of precedent.
Yes, my lord.
Yeah, I thought so, but I just wanted to be clear about that.
Yes, and that therefore you should ask yourself, as the Upper Tribunal asked itself, are you extending? If you are you extending BJ Rice if you were to take up my learned friend's
Yeah,
invitation?
are you extending BJ Rice as subsequently reinterpreted by,
Yes.
authoritatively reinterpreted by
As
RSA?
authoritatively confined, I suppose.
Yes.
But I hadn't gathered that. So it is your position that the confining for which you contend is ratio in RSA and binding on us.
Yes, I'm sorry if that hadn't come across clearly.
Yeah. So in a sense, although intellectually we'd like to know the answer, Lord Justice Newey's search for how you reconcile that limited view with what the Court of Appeal actually said is irrelevant. Maybe you can, maybe you can't, but the House of Lords has told us we must. It's only perhaps relevant to the extent that to see whether even the confined version applies to our facts. It might not be. We might want to do our best to understand the thinking behind what the confined version is. But we've been told, admittedly in very short terms, by Lady Justice Arden, that this is the only situation in which it applies.
And that's why, with very greatest respect, I think one can have some security in focusing on the supplier being somebody outside who wasn't a taxable person, wasn't registered or required to be registered, and was outside the VAT system altogether, because that seems to be the circumstance in which you're being told BJ Rice is confined to in our submission. And then it's pretty clear in our submission to work out that you are extending that. Because, of course, in the real world, BJ Rice was making supplies, etc., not registered for VAT. So, being in the real world here, Silverfleet is making supplies for considerations. It's got its contract with PHC. The only element, it's also in the real world, it's carrying on business. The only element that can be said is it's not a taxable person because it's only an ordinary member of the representative members group. But in our submission, that would be extending the reasoning of BJ Rice to a situation which is clearly everything's happening outside the VAT system, to a situation clearly everything is happening within the VAT system. And then you simply, maybe you have to go and say, what rules do you apply for saying whether a transaction is a transaction of a single taxable person, intra, or to a third person? And we say the answer must be the time of supply rules. And certainly BJ Rice doesn't provide any basis, because it would require my learned friend to persuade you that it should be extended to a situation where one's very much within the VAT system, where the particular taxpayer is having to rely on a assumption, Article 11 is a deeming provision, Section 43(1) is an assumption, a disregard, and a deeming provision.
Sorry, we keep stopping you from getting on, but each time we do, at least learn a little more. So that's good. Where you wanted to go now?
Can I just, for your notes,
Yeah.
just say this in terms of I haven't found any more legislation than we have in the bundle about VAT Group registration. But if you were, I really don't want to take time going into now, but if you look at Authorities Bundle, page 17, which I think we may have looked at briefly, section 43B1, which deals with applications to join VAT groups. An application can be made on behalf of 2 or more people. It's obvious that those companies must be identified to HMRC in the application. One and only one will be the representative member. And at 43C on page 19, HMRC can terminate a single member's membership of a group. So again, it's clear that they have to know who the members of the VAT group are and will know. I don't believe there's any VAT register that you can just look at and see as a whole on the internet or anywhere else. You can phone up HMRC or interrogate the internet if you have a VAT number to check whether somebody is registered. And in terms of the record that's created by HMRC, you saw that list of companies with the representative member denoted 000 and all of the other members listed with a 001, etc. number.
Yes, I'm not sure this is central, but I mean, that nevertheless means that as individual companies, while in the group, they are not registered for VAT in the sense in which that term is normally used, and I think statutory is fine.
In our submission, they are registered for VAT. What they can't do is have their own individual registration number, and they can't submit their own.
Yeah, I thought being registered for VAT meant you did have your own registration number.
Well, it normally would, but if you're a member of a group, there's just one registration number for.
Yeah, well, I see all that, and I'm not ultimately sure how much it matters whether whether they are formally registered for VAT in their own right, what the answer to that is. But if it does matter, you haven't persuaded me at the moment that they are registered for VAT in the normal. We haven't been shown any of the provisions about this. It may all be a science show, so don't go there unless you need to.
I mean, I've taken you to those provisions which show that there's group membership, and it's clear that the members of the group are VAT registered, but they don't have their own registration number.
Well, I'm not going to press you on this unless my lords are. But it sounds as though you don't think you need to go.
I mean, the first way I'm pressing it is that I say that the relevant time Silverfleet was actually registered for VAT as an ordinary member of PAC's VAT group, and that's not being an ordinary member of a VAT group is not a nothing for VAT purposes. I think that's obvious. It clearly must have consequences, and if that's wrong, if formally I shouldn't be calling them registered and you shouldn't be describing them as such, then they're clearly not outside the scope of the VAT system, which is the distinctions I'm making with BJ Rice.
I mean, the page that was handed up to us obviously governs registration, but it's all the material provisions are in schedules, which we don't have. We'd find the answer there. With enough diligence, we would see whether appearing on the kind of document that you showed us in the supplementary bundle counts as registration or not. But you say ultimately that doesn't matter because they're part of the VAT system.
Yes, but I also yes, I think I shouldn't repeat it. I think you see useful things from 43B and C.
And just to be clear, you don't have to belong to a VAT group. You can choose. I mean, suppose you have a corporate network with various subsidiaries. They don't all have to belong to the group. They have to apply for membership of the group.
So it's a choice whether there should be a VAT group or not.
Yeah.
It's a choice who the members of that VAT group would be. In realistic economic terms, it's a choice for the company or the owners who control them all. There are various other matters that may occur in case of abuse, but I don't think we need to consider those.
So, I mean, there was no obligation on Silverfleet to be a member of the group. It was a choice for the group whether or not it was a member of the group.
Yes, and it was also a choice for the group, or it was a choice for the controller, can I call it that, of the group, whether they decided to sell Silverfleet to the managers of the group. So it was a choice whether it left the group, although once they'd made that decision to sell, and it was no longer over the same control, the choice they had made had the necessary consequence that it would leave, Silverfleet would leave that group.
Can I ask you a different, but I think possibly related question? One of the points Ms. Young made was that while in the group, Silverfleet was not a taxable person, and she showed us a decision of a CJEU to that effect. I can't remember what it's called, Alfratelli or something.
Scientific.
And that's the one. This is connected with you. Your answer to that point is connected with this question. Silverfleet was a member of a VAT group. Is it your submission that Silverfleet was a quote taxable person, or that it doesn't matter whether it was or not?
It was part of a single taxable person. There's a single, as we've seen and we'll see, there's a single taxable person concept in Article 11. But there's no template from Article 11. So member states can go about effecting the single taxable person in various different ways.
And the way in which UK has done it is by requiring a body corporate that is a member of the group to act as the taxable person on behalf of everybody in the
The
group.
representative member.
Representative member. And one of the lordships, I think it might have been Lord Hoffman, said you could have done it a different. You could have had a notional composite person.
You could create a new legal person.
Exactly, for that purposes. That's not what's done. You take
No.
an existing legal person who's a representative member, then they're the only one that is the taxable person. But does it not therefore follow that Silverfleet is not, in its own right, a taxable person at the time that it's in the group? Because neither the transactions it makes with other members of the group nor the transactions it makes outside the group are supplies deemed to be made by it as a taxable person.
I think, sorry, did I?
No, that's the question.
I think the right analysis is that Silverfleet is one of those persons that are treated as a single taxable person.
Right.
It's a member of the VAT group in UK terms. But there's nothing, it's not cigarette paper between the two analyses in our submission. So if you had created, don't get too much into a hypothetical that doesn't exist, but we would certainly be submitting if you had the creation of a new single taxable person legal entity.
For VAT purposes,
For
called
VAT
the
purposes.
Prudential Group
Yeah.
was a single taxable person for VAT purposes, then you would say that Silverfleet was part of that entity.
Well, what I was going to say is I would be saying that the right approach would be to apply the time and supply rules to work out whether any transaction was a transaction that had been made by the single taxable person, either received by the single taxable person or supplied by the single taxable person, or whether any transaction was an intra-group transaction.
Yes.
Or an intra-single taxable person transaction. That's the equipment one has from the PVD and the equipment one has from VATA. And that's the way to establish whether Article 11, which is a deeming provision, applies to particular supplies. Just do it consistently using the same time of supply rule that you would for any other purpose within the VAT system, and not extending the reasoning of the Court of Appeal where somebody was just not engaged with the VAT system at all in BJ Rice, a difficult case in terms of justice and common sense, any wider. Certainly to not when you've got this level of engagement and you're trying to work out whether deeming provisions, either Article 11 in the PVD or Section 43(1), apply. So it's in our submission, what you've got to determine is whether a deeming provision applies. And whether you look at that as Article 11 or whether you look at that as Section 43 and the parts of Section 43. The conventional, legally certain and appropriate way to do that is simply by applying the time of supply rules. What Article 11 is particularly concerned with is the treatment of transactions, we can say supplies here, whether a supply is to be treated not to exist or disregarded, or whether it's treated to be supplied by or to the representative member. So it is transaction focused, if you like, supply focused for our purposes.
You say you need to know what the time of supply rules tell you about when that supply took place before you apply the deeming provision.
Whether it's Article 11 or whether it's Section 43(1). And with respect, I think this case would be a lot less complicated, but for BJ Rice, which takes at least as far as it applies this generally or widely, what I think you can now see is an unorthodox and wrong view of when you can just ignore the time of supply rules and look at events at the time something was actually done. Because otherwise, in our submission, it's just a reasonably straightforward exercise. What would you do other than apply the time of supply rules? Why would you look into the judicial bosom to find some other rule to apply? The consequences of the single taxable person VAT grouping. Well, one is, we know an object is the simplification of administration. So that applies so long as both are in the VAT group. Then the focus on that is, or beyond that, is really on transactions. How are transactions dealt with? Are they to be disregarded because both parties were in the group at the relevant time, or are they to be treated as supplied by them? And it's all basic, isn't it? But the time of supply rules equip you to decide that perfectly well. And so it's very dangerous in our submission to get into. But isn't this a situation in which the Silverfleet was not a taxable person because it was part of the VAT group? What justification does that give for not applying the time of supply rules? And this I think brings me on to, I think I've now dealt with as much as I need to in my skeleton and submissions to you, ground 1.1 and ground 1.2. And so now I was going to go on and look at the assumption, and then I'm going to tie it all in. I might end up repeating myself a little, I hope not, on European law and why it's not contrary to European law to take this approach. The assumption, your lordships, yesterday.
No, I'm sorry.
Yeah, of course.
To keep asking you questions, but can I go back to I mean, I have your submission, which is it's not actually relevant on the way you invite us to look at it. Whether Silverfleet was, quotes, a taxable person before it left the group or not, because it was within the VAT, the scope of VAT, and therefore you just apply the time of supply rules, and that tells you what time of supply, and hence whether Section 43 in the disregard applies. I have that submission, but suppose it is critical to ask the question whether at the time of actual supply, Silverfleet was a, quotes, taxable person. Do we get any assistance on that from Section 43(1) AA, which is quite a complicated provision we haven't looked at, which appears to say,
May I just get there, my lord?
of course, I'm sorry, it's throwing an unexpected question at you.
Well, I'm sure you should be very clear that, sorry, the section,
Section 43, subsection 1AA, which is on page 10 of the authority.
When did that come in? Just so we. Oh, I see. When did it-
2004.
Yeah. Okay. Sorry, going back to the substance of my lord's question.
Well, it appears to say that if you have a supply outside the group, which is treated as supplied by the representative member, although in fact supplied by an ordinary member, and there's a difference that would be material between the description applicable to the representative member and the description applicable to the actual supplier, then the representative member is treated as having the description applicable to that body. But then subsection 1AB says it doesn't apply to the extent that what is material is whether a person is a taxable person. And I assume that's because whoever drafted this thought that we don't want it being said that what's material is whether the representative member is treated as a taxable person or not, because we do want them to be treated as a taxable person, even though the actual supplier is not a taxable person. Is that right? But maybe you might want to think about that rather than expecting you to deal with it straight away.
I think I can deal with at least the first part of it. So the situation is you might have, for example, a holding company as the representative member. And that might be a holding company for a group of care homes that make supplies of residential care. Now, in order to benefit from that exemption, the supplier has to be properly regulated by the Care Quality Commission. So you could have
The representative member might not be regulated, but you treat it as if it was.
Exactly, because otherwise the suppliers would be deprived of.
Yes, no, I understand that.
So this is an example of looking into the black box. It's not all a black box at one. And equally concerningly, if the representative member was regulated by the CQC, but other companies were providing care not regulated by the CQC. So that's what it's sort of thing that's intended to do with. I'll try and take some instructions, but I mean that just seems to be carving out that if something turns on whether somebody is a taxable person or not. Now I can see that that might be thought to be cast some light on whether an ordinary member is a taxable person, but in my submission, it doesn't. It might work. It's probably just involving anybody having to get involved in that sort of discussion at all when you have a single taxable person.
I mean, just talking about this a moment longer, I mean, we see in section 3 who is a taxable person within the meaning of the legislation. And Silverfleet will not be a taxable person within the meaning of the legislation, I assume. But that isn't really your point. You say, well, whether or not it is appropriately described as a taxable person within the scope of this legislation, the fact is it is within the scope of VAT, and VAT is payable on the services it provides.
But that's, with respect, that's not the way I read it. Let's say Silverfleet's And it's never been suggested that if you looked at Silverfleet as an individual company, it wasn't a company that was required to be registered in accordance with the schedules.
Yeah.
So if you looked at a position Silverfleet had not been part of the VAT Group, the VAT Group had included everybody else but not it, it would have been required to be registered. So it may well have been individually registered, but if it wasn't, it would have been required to be registered. So we'd say the reality of it is that Silverfleet is required to be registered, but that it discharges that requirement by being an ordinary member of the VAT Group, of PAC. And that doesn't mean that it can act individually for VAT purposes whilst it's a member of the group. It can't put in returns. It doesn't have its own number, but it is in our submission within the registration scheme.
Yeah.
Yes, I see.
Keywords are required to be then.
Yes. And I think one takes a realistic view of that, and the purpose. I mean, the purpose is that people who are carrying on business and meet the requirements for registration should be registered. It's not as if in our submission they're dispensed by that from group registration. They can't do it secretly and not name themselves the commissioners. They have to declare themselves and they become VAT registered as part of a group. And that doesn't deny the distinction between an ordinary member and the representative member.
Yeah. Right.
So
We may or may not allow you now to start speaking about the assumption.
Sorry, did you
Not
say,
is the answer.
not, I'm so sorry. Did you say earlier that the register of who is registered under each VAT number is publicly available?
no, I don't think it is.
It's not. It's not. So it's not possible for.
May I just,
Yes.
in case I'm saying, so the VAT register can be searched by asking the commissioners a question about it, or by putting in a VAT number, for example. But you can't go onto the internet and yes, you can't go onto the internet to see a list.
But you can type in a number and see who is registered under that number. Yes? No? It looks like the answer is yes.
Yeah.
If you type in a number which is in fact a number for a group, do you get a list of all the members of the group?
There's a suffix given, which I think we've seen.
Yeah.
000001. If you put 000, you'll get the representative member. If you put 001, you'll get whoever is
You
listed
could,
one.
as a member of the public, with the Prudential Group's VAT group number, discover by a slightly tedious iterative process who each of the members of the group were.
I think you need the number, and I suppose you could then guess the suffix. I don't
No,
think-
well, you wouldn't get.
You
No,
just go
you-
through each one in turn.
You just go /1, /2, /3, and then when you get to /15 and there aren't any more, then you know that's everyone in the group. Is that's I think what
I think that's what we're being told. Is it?
That seemed a little, in fairness, I rather sprang it
Yes.
yes.
on my client. So we'll check it.
Yes.
That
And it's
was-
not as straightforward as that actually, because if we look at the example we've got at 88, the numbers don't appear as slashes, they appear as, they've been described as a suffix, but they don't actually look like a suffix. And there are, let us say, I haven't actually counted them, probably about 25, 30 numbers there. They go up to 61 because quite a lot of them, presumably, you go 1, 2, 4, 5, 6, 7, and then the number between 7 and 14, and so on, which I suspect reflects the fact that historically there have been other companies in the group which have fallen out,
Left group, yes.
probably. But I don't, looking at that, and given that you haven't got clear instructions on the point, I'm not myself satisfied the answer to my Lord's question is what we begin to think it was.
Well, with
How
respect,
much this matters, it's very secondary to your submissions.
well,
We need
yes,
to feel firm ground under our feet.
No, I'm grateful for that indication, but whether it pivots on whether the commissioners have a public register which shows the members of the VAT group, or whether if you search you can find the individual, I find it very hard to believe
I
that's
can
the
see
route.
why you find that hard to believe, and you may well be right,
Yeah,
but
yeah.
still, if you're sitting up here, you just don't like feeling there are things you don't understand.
No,
This is one of them.
I quite understand, and I don't feel myself that I've bottomed that out and given you a guaranteed accurate answer. So we'll try and do that. Unless you want to dispense with
No,
me.
I just thought it might assist you on the question of whether Silverfleet required to be registered, whether it was in fact registered in some sense.
Well, we've seen it's registered in the sense that the commissioners put it on a
Yes,
on a list.
but registered clearly has a meaning under the Act, which is defined effectively by Schedules 1 to 3A, which we haven't been given, and we haven't been told, therefore, how Silverfleet does or doesn't figure. Now, you may well have made a forensic choice. That's not something you have to demonstrate. Fine, which is in fact we looked at this last night, and I've got no problem with that. But if there is something to be mined out of that, you've got to give it to us, because we can't tell from what we've got.
I don't think there is, but I can see that there's an onus on me to check.
My lord, I tend to agree with that. Again, I may be corrected, but I have looked at the schedules, albeit not recently, and I don't recall there being anything specific in there applicable to VAT groups. But we will check.
No, well, I rather guessed that was the case. Otherwise, we would have been shown them, I think, as a result of your overnight researches. But
So, round two centres on the assumption in the opening words of section 43.1. I don't suppose we need to go back to 43.1. I don't know if we're all up page, it's tab 7, page 85, back in Thorn again for one last time, I think. Right.
Torn, yeah.
Yes. It's page 85, just below D to just below G.
Yes.
So we submit that Lord Hoffman correctly identified the purpose of the assumption. It's not something that the Upper Tribunal fastened onto, although I believe it was shown. And it's not something which you'll find contradicted in any other authority before you. So the purpose is a narrow one, to enable any supplies made or deemed to be made by the representative member to be treated as made in the course or furtherance of a business carried on by the representative member. So that's because the UK version of single taxable person works by reference to deemings and disregards. And one can see the open quotes, clever end quotes, possibly awkward person saying, well, I haven't made a supply as representative member to a third party because although I'm treated as making the supply, the business was actually carried on by the ordinary member of the group, and then therefore there's a mismatch in the conditions necessary for chargeability. Lord Hoffman makes that point. I think a similar point can be made in terms of recoverability of input tax, because if a supply was deemed to be made to the representative member, but it was used in the course or furtherance of business of an ordinary member, then the conditions for recovering input tax would not be satisfied. So it prevents that sort of technical objection, preventing supplies which ought properly to be within the scope of the tax falling outside the scope of the tax because of technicalities in the way the United Kingdom has implemented the single taxable person concept. So the assumption is linked to section 43(1)(b) and that deeming provision, and not to paragraph A. And if Lord Hoffman's right, then it's right that in order to determine whether paragraph A disregard applies, one has to apply the time of supply rules, but one simply applies the time of supply rules once. And that makes sense because apart from the overarching objective of VAT simplification, what we're dealing with in VAT inevitably is the treatment of transactions, including supplies. And repeating myself, I'm afraid, all of those supplies and all of the other transactions have time rules that fix when they occur for the purposes of VAT. And the question still, as with section 43(1)(a), is were the representative member and the ordinary member in the same VAT group when the supply took place for VAT purposes. So the Upper Tribunal's reasoning on this at paragraphs 32 and 33 was right. You apply the time of supply rules to see if the paragraph A disregard applies. If it doesn't, there's no need for a second step where, using a different approach to time from the time supply rules, you go back and start making assessments at a time when the services were actually rendered. And if you were to consider whether the assumption fits well, first I should say this, the assumption fits very well with the operation of paragraphs B and indeed C of section 43(1). It doesn't fit if you were to consider how it might fit with paragraph A and the disregard. In our submission, it doesn't fit well at all. It would also forgive me a moment. There will be no need for any disregard in respect of supplies of ordinary members which were intergroup, because if the assumption applied to intergroup supplies, then intergroup supplies would already, if made by the ordinary member, not fall into taxation because they're treated as the business is being, the ordinary member is treated as being carried on by the representative member. So there would only be need to take a particular step in order to disregard supplies which are made into group by the representative member. Otherwise, the assumption at the start of section 43(1) would have already done the job. So that's further basis, and I think that's contemplated by Lord Hoffman himself in the Fawn case. And so we say that the purpose of the assumption is to ensure that paragraph B operates paragraph B operates rationally. There is no reason for extending that deeming provision further. Now, my learned friend says in our submission that the assumption should fulfil a different role in UK law. She says the assumption should operate so because although one has to, when considering the disregard at A, if she's lost on ground one has to apply the time of supply rules, and that locates the time of supply outside the VAT group. That when all the relevant conditions for the chargeability of VAT apply, that's still not permitted as a charge to VAT, because at the time both companies were in the VAT group, the business of all the members of the VAT group was treated as carried on by the representative member PAC. And in our submission, that case comes down to this. It's a case really based on EU law, on Article 11 PVD. And it is that one can't apply the time of supply rules to determine whether or not a supply is a VAT group's internal transaction. And we say if Article 11 doesn't prevent the UK from applying the VAT time of supply rules to determine whether or not a supply is a VAT group's internal transaction, then PAC can't succeed in this appeal. As you'll recall from yesterday, Article 11 itself, and perhaps it's wise, although you'll be very familiar with it now, to go back and look at it. And Article 11 is on page 31 of the Authorities Bundle, tab 4, page 31. If you could be so kind to look at that again. And it refers to regarding as a single taxable person, persons who are distinct legal persons. So it's clear on the face of the legislation itself, there's a single taxable person concept. And then we've explored that in a number of authorities, 3 CJEU cases, Ampli Scientifica, Commission Island, and I'll call it Laurentia, and the commentary on them in 2 domestic cases, Taylor Clark in the Supreme Court and Lloyd's in the Court of Appeal. And we submit that it's important to have regard when addressing my learned friend's submissions to what the purpose of Article 11 is. And we've seen the Court of Justice's succinct statement of purposes at paragraph 47 in the Ireland judgment. That's for just your note, Authorities Bundle 319. 2 purposes: simplification of the administration of VAT and combating abuses. So the only one that's relevant here is simplification. And so it's often nice to wait to see the whole, but it's worth pointing out here that simplification of administration does not require and cannot justify non-application of the time of supply rules in determining whether a transaction is an internal transaction of a single taxable person.
The other thing to be equal, it might be thought to conduce to the purpose.
Well,
But sorry, I'll let
in our submission, it brings legal certainty. It brings one set of time of supply rules operated consistently across the VAT system. And it would be a complication of the VAT system to start applying different rules in respect of VAT grouping, and in particular, whether a transaction is an internal transaction of a VAT group. So also from the authorities I just mentioned, you get the required consequences of a VAT group. And it's an open textured provision. It doesn't go into much detail, does Article 11, but this we do know. Members of a VAT group have to be treated as a single taxable person. So that's called emphasising something we find in Article 11. And then there are the following consequences. First, and I'll put these in UK terms, the ordinary member of a VAT group cannot submit its own VAT returns. The ordinary member cannot have its own VAT registration number. The VAT group's internal transactions do not exist for VAT purposes. They've got to be disregarded. And external transactions made by have to be treated as made by a single taxable person. So in our mode of VAT grouping, by the representative member. You were taken to the Commission communication. In our submission, that adds nothing of significance to the authorities. So those are the consequences that my learned friend draws out of the authorities. Those consequences of VAT grouping don't dictate that a member state cannot apply its time of supply rules to ascertain whether a particular supply is to be treated as made by or received by the single taxable person, and more directly relevant here, whether a particular supply is to be treated as an internal transaction of the single taxable person. What it does tell you in our submission, because it doesn't provide any other rules in the time of supply rules, is that if applying the time of supply rules, a transaction is an internal transaction of the VAT group, it must be seen as not existing and disregarded. But we would say, if applying the time of supply rules, it's not an internal transaction because it doesn't take place at a time when both supplier and recipient of supply were members of the same VAT group, it's not an internal transaction. It does exist and is not to be disregarded. And in a way, this is the European, correct, we would submit, EU law focused, PVD focused way to looking at the potential chicken and egg dilemma. So a very quick recap, and we really do submit it is relatively straightforward. The purpose of Article 11 doesn't require a member state to do anything other than apply the time of supply rules to determine whether transactions are transactions of a VAT group, a single taxable person. Applying the time of supply rules fits better with administrative simplification, although I don't need to go so far as that. The consequences of VAT grouping, as recognised by the Advocates General and the Court of Justice and the UK courts commenting on those opinions and judgments, don't dictate and certainly don't favour a member state being prevented from applying its time of supply rules to determine whether a supply is made when two members are part of the same VAT group. And again, for fear of being repetitive, the time of supply rules, including regulation 90 amongst them, apply generally when fixing when a supply occurs for VAT purposes. There's no specific exception relating to Article 11 in Article 11 or anywhere else in the PVD. I'm not sure how much rules on deeming provisions help general rules in this particular context, but it can be remembered that Article 11 itself is a deeming provision. So it might be thought surprising if a deeming provision deeply embedded within the VAT system was going to depart from following normal rules in relation to the times of supply without some express flag of that or some express alternative provisions point being made. I think perhaps one further point was being drawn by my learned friend, perhaps more out of the Commission communication, but out of the Advocate General Justin's opinion in Ireland as well, which was the analogy between a single company with two divisions. In our submission, for the reasons that were expressed by the court, I think particularly by my Lord Justice Newey yesterday, that's not a helpful comparison. You just have, before the demerger or the creation of a new legal person, you just have a single legal person. Its employees do various things for various parts of the company, and there'll be no doubt accounting entries between parts of the company, but in our submission, it's not a helpful analogy when it comes to between somebody leaving a VAT group and a demerger into two companies, because there's just simply nothing done for someone else and no payment in return. And one would need to see what the terms of the demerger agreement were, because the legally a binding obligation to pay something would be brought about by the demerger agreement. And for that purposes, one would need to look at the demerger agreement and see whether that had any back consequences or not. So far as those comments which say a single taxable person is like a single legal person. Inevitably, it's more complicated than that, because people can leave and join a VAT group. There's no doubt that Article 11 permits that, and so does the VAT implementing legislation. But perhaps this isn't facile. I worry little that it is. But if you are looking at a single taxable person, there's just no question that the time of supply rules apply as Lord Hoffman described them as applying. Sorry, I'm not sure if it's a single taxable person, a single legal person. The time of supply rules apply as Lord Hoffman described them in Thorn, and for reasons that I don't want to re-enter into, what one doesn't have to concern oneself with BJ Rice in this scenario. I've got one more point to make on ground 2, which is reasonably short, but requires little engagement, and then I'm on to ground 3, which is extremely short, and I think
Round 3, right? Yes, I mean, Ms. Young hardly developed at all.
Yes.
So, well, in your hands, I think there's some advantage in hearing you out.
yes.
But if either you just feel you need a break, or that it will be more than, let's say, 10 minutes.
Well, can I try and finish, and then
Rather you do that.
perhaps my learned friend would have heard all of it as well. And if there's something that occurs over lunch,
You can finish with the locus penitentiae,
thank you.
providing you do it within 10 minutes. 5, you would get extra points.
So the point that my learned friend makes about the assumption depends on who is identified as making the as carrying on business. And in section 43(1) assumption, it's the representative member that's identified as carrying on business. So if my learned friend is right, and what matters in this case is that the business was carried on by the representative member PAC at the time the group was in existence, and not by Silverfleet, then you come up with exactly the opposite answer if the internal supply is made by the representative member to an ordinary member. Because in that case, you don't have any mismatch. The representative member is carrying on business. The representative member is deemed to make the supply. So there would be no basis on saying that somehow because of that, the time of supply rules could not be applied. So in relation to internal supplies of the VAT group, you would have a disregard if supply was by the ordinary member to the representative member, but not if the supply was by the representative member to the ordinary member if the assumption is critical. And then there was a point made in the Upper Tribunal that we said there was something satisfactory to help on the application of the time of supply rules to paragraph A, that the time of supply rules would then apply to paragraph A and to paragraph B. And below, the answer to that was, well, there's no need to worry about inconsistency. Paragraph A is a disregard, paragraph B is a deeming position. They've got entirely different functions. But a different solution to that emerged yesterday in my learned friend's submissions, because she said the same way in which you approached paragraph A in terms of looking at what was actually received and the time of supply rules. So you could have this if actually received in the, well, both members of the VAT Group disregard. If not, apply the time of supply rules, and time of supply rules might bring you back into the disregard. So that approach ought to be taken as well to paragraph B. So when looking at the relationships between a single taxable person and third parties, one would have to take exactly the same course. You'd first of all apply the actually made rule, and that would dictate the VAT outcome if it was actually made at the time the representative member was a member of the group. Sorry, at the time that the real world supplier was a member of the group. Or you'd have to go through the same cycle, apply the time of supply rules, that might take you back into group membership. And here, I think one really sees why one's not got simplification and one does have complexity. Because in our submission, when dealing with third parties, it's essential that the standard time of supply rule should apply. And that's pretty obvious, we would say, from the looking at it from the point of view of outputs of the single taxable person. But then, if the time of supply rules don't apply in a normal fashion to the outputs, you have to have this actually performed, then what about to inputs of the single taxable person? Would you have to look at for a continuous supply at when the supplies was actually received by an ordinary member or the representative member of the VAT Group? And if they were actually received while they were a member of the VAT Group, you wouldn't just apply the normal time of supply rules. You'd say, well, that's when they were actually received, and that's when VAT is chargeable, which would leave the third party supplier who would expect that the normal time of supply rules would apply, so not have to account for VAT other than in respect to the period where the invoice or payment was received, having to intuit or be told that because this supply actually took place when two members were members of the VAT Group, but one has subsequently left, you can't apply the normal time of supply rules. You have to treat your supply as actually made, sorry, as made when it was actually received. So at some point, those are peripheral to the principal points, but they do show the difficulties that start to arise when one starts not applying the time of supply rules. In our submission, by trying to bring consistency between A and B, one shows that that's not a solution for B at all. And one also shows why a consistent solution between A and B, simply applying time of supply rules, works best. Ground 3, is an attack on paragraph 108 of the Upper Tribunal's decision, which for your notes is called Bundle 98. And the tag to the ground is that the Upper Tribunal was wrong to say that this appeal was not concerned with the consequences of that grouping. I think there are three things to say. One, it really adds nothing of any significance to grounds 1 and 2. There's no need to do it now, but were you to look at the Upper Tribunal's paragraphs 106 to 108 and see exactly what the Upper Tribunal said and the context of PAC submissions it was addressing, there was no error of law by the Upper Tribunal. And thirdly, you have my written response, which is at HMRC skeleton paragraphs 52 to 53, core bundle 72. And I think unless you want me to, I need to say no more on ground 3. I think it's not been the case that I stood here and read out our skeleton for the past
Very
best part of
emphatically
the
not.
day.
No, you've engaged, as indeed is with a great deal of
There are
questioning from us.
there are some points in the skeleton that may be worth going back to, and I stand by them all. Can I have a moment just to make sure there isn't anything else? Really, a moment.
Yes.
I will just check more thoroughly over the luncheon adjournment and see if we can come back with answers to your outstanding points.
Yes, thank you. Should we just say 2 o'clock?
I'm happy either way.
Well, unless it puts you in difficulties with your arrangements over the break, why don't we just sit at 2? I think it'd be more useful to everyone to have 10 minutes more in the afternoon than 10 minutes over lunch. But okay, 2 o'clock it is.